This $200 HOA fine turned into a $15,000 legal nightmare. Here's how it happened. Started as a simple $200 fine for leaving Christmas decorations up 3 days too long, turned into a $15,000 legal battle that nearly cost the Johnson family their home. And if you think HOAs can't do this to you, you're about to discover just how wrong you are. This story will change everything you thought you knew about homeowners associations and their power over your property. The innocent beginning meets Sarah and Mike Johnson from Riverside HOA in Colorado. Like most homeowners, they thought their biggest HOA worry would be keeping their grass the right shade of green. They'd been model residents for 8 years, never missing a payment, never causing trouble. But on January 7th, 2023, everything changed when Sarah found a bright orange violation notice taped to her front door. The crime: their Christmas wreath was still hanging for days after the January 3rd deadline stated in the Community Guidelines, page 47. Subsection 12-B. The fine seemed ridiculous, but Sarah figured she'd just pay it. After all, $200 wasn't worth the hassle of fighting City Hall, right? This is where most homeowners make their first critical mistake. And it's exactly what the HOA was counting on. The first red flag: when Sarah called the HOA management company to pay the fine. The representative, Linda, seemed unusually eager to process the payment immediately. "Oh, you definitely want to pay this right away," Linda insisted. "Because if you wait, it could get much more expensive." Sarah should have asked why, but like most busy homeowners, she just wanted the problem to go away. She paid the fine that afternoon. But here's what Sarah didn't know, and what your HOA probably isn't telling you either. By paying that fine without challenging it, she had just legally admitted guilt to violating the covenant. This admission would later be used as evidence that the Johnsons were repeat offenders who showed a pattern of disregard for community standards. The trap springs 3 weeks later. Another orange notice appeared. This time, their mailbox was supposedly 2 inches too far from the curb. The fine had mysteriously jumped to $400. When Sarah called to dispute it, Linda's tone had completely changed. "Well, according to our records, you're now a repeat offender, so the fines are doubled. Plus, there's a $50 administrative fee for processing disputes." Sarah demanded to know when this rule about repeat offenses had been implemented. Linda casually mentioned it was in the recent amendments that were mailed to all residents. Sarah checked her mail stack and found nothing. When she pressed further, Linda claimed the amendment had been posted on the community website for 30 days. Which constituted proper notification according to state law. The legal quicksand. This is where the Johnsons' nightmare truly began. And it's the same trap that thousands of homeowners fall into every year. Sarah hired a local attorney, David Chen, thinking a simple letter from a lawyer would resolve everything. The retainer was $1,500. Which seemed reasonable for what should have been a straightforward dispute. But Attorney Chen discovered something that made his blood run cold. The HOA had been systematically targeting long-term residents with perfect payment histories. Why? Because these homeowners were more likely to pay fines without question, and their clean records made them appear non-compliant when they finally did dispute something. The smoking gun discovery. During the legal discovery process, Chen uncovered internal HOA emails that revealed the true scope of this operation. The board president had written, "Focus enforcement on the quiet ones who always pay. They won't fight back, and when they do, we have documented violations to justify." Escalation. Another email discussed revenue enhancement through targeted compliance actions. The HOA had been manufacturing violations and using homeowners' own compliance against them. Sarah's quick payment of the Christmas decoration fine wasn't just recorded as payment. It was categorized as an admission of guilt that could be used to justify future actions. The $15,000 Bomwin Chen filed a formal dispute challenging the mailbox violation. The HOA responded with a lawsuit claiming the Johnsons owed over $12,000 in accumulated fines, legal fees, and collection costs dating back 2 years. They claimed the Johnsons had been repeat violators of various obscure covenants, including excessive outdoor lighting from their porch security light and unauthorized landscaping modifications for planting different flowers in their front garden. The legal fees to fight this lawsuit, another $8,000, bringing their total exposure to over $20,000. All stemming from that initial $200 Christmas wreath fine. The shocking resolution after 6 months of legal battles. Chen discovered that the HOA's management company had been operating without proper state licensing for property management services. This single finding invalidated every fine they had issued for the past 18 months. The Johnsons not only had all fines dismissed, but received a settlement that covered their legal fees and compensated them for the emotional distress. But here's the terrifying part. If Chen hadn't found that licensing issue, the Johnsons would have lost everything. The HOA had the legal right to place a lien on their home and eventually force a sale to collect the debt. Your protection strategy: ever pay an HOA fine immediately without documenting everything first. Request all supporting documentation, take photographs, and always respond in writing. Most importantly, know your state's HOA laws and your community's actual governing documents, not just what the management company tells you. If this story opened your eyes to the hidden dangers lurking in your own HOA, smash that like button and subscribe for more shocking HOA investigations that could save your home. And drop a comment below, sharing your own HOA horror stories, because together we can expose these predatory practices and protect our communities.